Is a director at Fortfield Brown, which is a specialist legal firm with expertise in construction law, contract training, and dispute resolution. And William has a wide range of clients, from large public sector bodies to small subcontractors, and he advises clients on all aspects of construction law and is a lecturer in construction law and dispute resolution at Queen's University, Belfast. I know some of you will have attended webinars or presentations that William has given before, which have always been excellent, and I'm sure today will be no different. Just a little bit of housekeeping before we start. William, I think you're happy for people to put questions in the chat as we go along, rather than leaving all Q&A to the end.
Yes, that would be great. So you've got two ways to do that. You can put it into the chat box or into the Q&A, and I'll keep an eye on both of those as we go along.
Brilliant. All right. Over to you then, William, please.
Yep, thank you, Daniel. So we'll make a start then. So Daniel has introduced me, thank you very much. And then on to the agenda for today. So we're looking at one core topic today, folks, and that is the official NEC4 amendments. When I say official, these are the amendments published by the drafters of the contract itself. So they do hold quite a lot of weight, and they do all serve a purpose. So the first thing that I would like to say from the outset, if you are in the process of entering into new NEC4 contracts, you would want to make sure that you're getting these incorporated into those agreements. And I'll talk about how you can do that at the end. It's dead straightforward. But as I say, each of these amendments serves a purpose. So to make sure you're using the most up-to-date contract, try to get them in there. So preliminary point before we get on, quite a lot of the amendments in 2019 are minor in nature. They're typographical, changing the word right, as in someone's right, to their rights, changing the capitalization on a few words as well. So very minor, just to help with the interpretation. I'm not going to look at those because they are what they are. I'm going to look at some of the more important ones and some of the ones that actually affect the day-to-day running of the contract, such as our friend 63.5, which some of you may know. That is the main clause of the engineering and construction contract that deals with assessing extensions of time or assessing the impact of a compensation event on the planned completion date, to use NEC speak. Again, I'll look at how the amendment has been made to that particular clause and ultimately what that does for practitioners using the contract. Senior reps is a dead straightforward amendment, as is the PI insurance certificate. Again, they are more clarifying what people should have been doing anyway. So again, I'll get through those relatively quickly. Flash forward then to the October 2020 amendments. These two are slightly different. These two particular amendments follow some case law that came in late 2020. And I'll talk through the cases of Triple Point, which was a Court of Appeal decision. And based on that Court of Appeal decision, the NEC drafters changed the contract. They changed the wording of X7, which deals with delay damages. But step forward to 2021 in July, we had a Supreme Court decision on the very, very same case, which basically set out that X7 amendment wasn't actually necessary. But having it in there is still going to be beneficial, and we'll look at that in detail. Then we'll look at the case of Rochford and Kilhan, which ultimately instigated the change to YUK2, which is all about not linking the final date for payment to the service of an invoice. That's what it's all about. That particular amendment only really applies in the professional services contracts, such as the professional services or the term service agreements. If you're only dealing with the construction contract, you don't really need to worry about that one. February 2021, it's a bit of a stretch to call it the amendments, but I wanted to get it in here anyway. That was actually the publication of the Australian and Irish Y clauses. And I was heavily involved in actually drafting the Irish version of that with my previous employer. And what those Y clauses do is they effectively bring the payment terms and the dispute resolution terms of the contract into line with the laws of Australia and the laws of Ireland as well. So we now have YUK, YNZ for New Zealand, Australia, and also Ireland as well. And then finally, one thing that I'll not talk about in too much detail because it's not strictly speaking an amendment to the contract, but that is pointing you towards the Construction Leadership Council's guidance on COVID-19. And they actually set out a couple of clauses that you can introduce into your contracts to deal with COVID-19 moving forward. And I'll provide a copy of that guidance at the end as well. So that's our whistle-stop tour. That's, giving you a flavour of everything that is to come. And we're now going to get into them in a bit of detail. So as I say, this is 63.5. If you don't know this clause, you should, because it's one of the most important clauses in the entire contract. It is the clause that deals with extensions of time and how the project manager and the parties are to assess the impact of a compensation event on programme. This wording that you can see on the screen, that is the original NEC4 drafting. So again, slightly different to NEC3, just in terms of terminology and whatnot, but it's largely the same. And largely speaking, it's broken down into two parts. The first part is how you assess a delay to the completion date, capital C, capital D. That is the contractual deadline. That is the date that you must meet. If you don't, then liquidated damages might apply if you have option X7 in the contract. So that's what the first paragraph is all about, and I'll come back to the rest of it shortly. The second part, which I'm not going to get into in any real detail, is how to assess the delay to any key dates, which again is a specific NEC term where you can set out specific conditions that have to be satisfied by this key date. And the contract sets out the repercussions if you don't do so. Our focus for the purposes of this afternoon is on the completion date. I'm sorry, I'm just going to double check. There's a question there. Sorry, it's just from Maureen. Just double checking. As I say, our focus today is only on the completion date and how this particular clause then has been amended. First off, how you assess a delay to the completion date under the NEC is slightly different to most other forms of contract. And that's the first thing you have to wrap your head around here, because the impact on the contractual deadline is not the impact on the deadline itself. It is the impact on the contractor's planned completion date. So if you plan to finish the works on the 1st of March, that is the impact, or that is the date that you have to impact with the compensation events. If you have 2 weeks of float between your planned completion date and your contractual deadline, capital C, capital D, that period is fixed and it moves out and it is pushed out due to the compensation event. I'm going to look at that in more detail shortly with a bit of a diagram to explain it. But that's just to set the scene for what this amendment ultimately does. And this is it here. So the amendment, as you can see, does two things. It deletes out the final paragraph of clause 63.5 and replaces it with a useful piece of text. And I say useful because I do think that this wording is very, very helpful in just reminding people of how to actually, use the programs to assess delay. So let's look at what it says. So it sets out when you're assessing the delay to the completion date, to the contractor's planned completion date, Morley, you assess any delay caused by the CE already in the accepted program. And the final part is the important element, that you also take into account things which have happened between the date of the last accepted program and the dividing date. The dividing date is the date in which the compensation event is notified. What happens before that is altogether different. You might have been running through the project quite well, getting lots of accepted programs in place, or you might not have been. The last accepted program could have been months ago. And if you were to read this particular clause, it talks about assessing the impact based on the last accepted program. And that then leads to a problem. How can you assess a compensation event reasonably or, logically speaking, if the program you have to use is 2 months out of date? It doesn't make sense. So what this clause reminds us to do is to impact the program up to the dividing date before you then carry out the assessment. You take into account things that have happened since the accepted program, which again could have been months old, and the date the compensation event was notified. So again, you just take into account reality and what actually happened on site. I say that this amendment is just a bit of a reminder because that's exactly what it is, and it's what people should have been doing anyway. And that is confirmed within the NEC practice note number 1. You know, if I was to get a show of hands here, who has actually heard of NEC practice note number 1? Who has actually used it before? Again, feel free to stick your hand up just to maybe get a bit of two-way dialogue here. There's one hand up there out of 71, just for reference, you know, so a very, very small amount of people have actually used that. I'm going to give everyone a copy of it at the end of this presentation because I want people to start using these practice notes because they are very, very good. And it simply confirms you use common sense, you update the accepted program to the date the compensation that was notified, and then you use that fresh program to assess the impact moving forward. So it's very useful. So just to confirm what we've just looked at, you know, by way of a diagram, the NEC is slightly different to most other forms of contract because it impacts the compensation events, not on the deadline, but on the contractor's planned completion date. And I'll show you what that means in reality just now. So there's two different types of compensation event. Largely speaking, there are compensation events which affect the critical path, and there are compensation events which don't. So the one that we're looking at here is a non-critical compensation event. So these ancillary works, as you can see, it can start, you know, at the same time as the condition survey, but it doesn't have to be finished until the installation works. This part in between, that is free float, and that can be used up by a compensation event without affecting the critical items and without affecting the contractor's planned completion date. So that's category number 1, if it were. Category number 2 are critical compensation events. Again, the opposite is true. They impact the critical path. And if something impacts the critical path, it's going to change when the contractor plans. Again, that's the operative word, plans to complete. As you can see on this little, you know, moving slide, hopefully everyone can see the animation. By impacting the planned completion date, it pushes out the completion date. Again, capital C, capital D. And what manifests when that happens is protecting the contractor's terminal float. If they had 2 weeks terminal float before the compensation event, they will have 2 weeks terminal float after the compensation event. And that is how 63.5 works. That is how it has always worked under NEC4 as well. So bear that in mind. So what we're looking at here in terms of the amendment is this scenario where, let's say you have the last accepted program, you know, just after you've mobilized to site, which wouldn't be uncommon. You know, you've got to site, there may have been delays in getting, you know, everybody on board, planning, whatever. But once you get to site, you update the program for all of the works moving forward. And that program can often become the accepted program. Then the program sort of falls away to the wayside, and you know the contractor might submit programs, but they never get accepted for various reasons. And ultimately, the only accepted program on the table was that first one way back at the beginning. Stepping forward in time, a compensation event then arises. So you know, let's say the design period is extended. For example, the employer isn't accepting the design, or the contractor hasn't submitted the design in accordance with the contract, whatever the reason is, that might be delayed. It might ultimately then trigger a compensation event. And what this particular amendment says or confirms is that you should take into account anything that happens in this period. You know, so if the sequence has to change, or the condition survey, which again would probably be the contractor's risk here, if that takes longer than planned or perhaps shorter, then all of that should be reflected on the dividing date to ultimately understand what the impact is on the planned completion date due to the compensation events. So again, it just, you know, underlines common sense in my opinion, but it is a useful amendment at that. What I have on the screen here, I'm not going to read out verbatim, I'm just going to give you the gist of it. This is an extract from that practice note number 1 that we have discussed. And again, it sets out if the accepted program at the dividing date is a long way out of date, which again, I imagine quite a lot of the audience here are well versed in this particular problem. Then it sets out what you do thereafter. And there's various different sort of permutations of that, but they all boil down to the same thing, that the parties should seek to agree on a program on which they then assess the compensation events. Again, if a compensation event has happened, get the planners to sit down together, again, PM and contractor all in the room, agree on what the program of works, the as-built sequence has been to date, and then impact it moving forward. It's all about impacting and having a program that makes sense at that dividing date, the date the compensation event was notified. So as I say, I'll provide that guidance along with the materials as part of this webinar at the end. That is moving us away then from the amendment to 63.5 onto a slightly different amendment then to do with the dispute resolution option under W2. This one's very, very short. I'm not going to dwell on it. We'll move on quickly. And it basically sets out that you can replace the senior representatives on the project. The reason I am actually discussing this, because it's a very, very straightforward amendment, is actually just to remind people that this exists, because the senior representatives as part of the dispute resolution mechanism is something which only came into NEC4. Dispute resolution is a very big part of what we do at Fortfield and Brown. So what I'm going to say sounds, like I'm doing myself out of the job, shall we say, but you want to avoid disputes as best you possibly can. And one of the very good ways that you can do that is by using this senior representatives mechanism within the contract, whereby if a dispute arises, and again, it's a very, very broad definition. If any problems arise that you cannot sort out with the operational people on the ground, then you can use this mechanism. Do the parties agree to use the senior representatives? I do not see why you would not do that. You know, to cut a long story short, why would you not have the senior rep sit down to try and sort out a problem before you have to bring in a third party and start to have to pay the lawyers and that third party themselves? The contract then stipulates, again, a very useful sort of prescribed way in which, the parties will then negotiate 10 sides of A4 paper plus the evidence. Again, there's no consequence if you don't stick to that, but it is good guidance. And ultimately, if you can't explain your position on 10 sides of A4 paper, you probably don't understand your position enough, is the way I think about that. And then ultimately, it gives you the ability to sort out the problem. If it turns into a compensation event, then you deal with it as a compensation event. If the contractor capitulates, then that's fine as well. But you get the dispute resolved between yourselves without having to ultimately result to the big bad A word, which is adjudication, which again is a costly way to throw the dice. It's an expensive way to throw the dice, more often than not. And again, just to recap, what the amendment does here, it just gives you the ability to replace your senior rep. For some reason, the NEC4, as originally drafted, didn't give you the ability to do that. But I suppose you always could have done it anyway. Moving on then to 15.6, again, boring clause for most people. But what this clause ultimately does is require the contractor to provide their PI insurance certificates on regular intervals. Whenever you renew that certificate, you have to provide it to the client. Again, most people would have done that anyway. More often than not, the professional consultants would have drafted something similar into the scope or the works information. But again, it's just underlining what people were always doing. And for those of you that don't know, option X15 deals with the design responsibility of the contractor. And if you are a contractor negotiating amendments to an NEC, you would always want to have X15 in. because it limits your liability for design to reasonable skill and care. And that is the standard which you can get insured, because that's what your PI insurance policies will cover. If you don't have option X15 in, and there is some sort of performance requirement within the scope, you do run the risk of that being a fitness for purpose obligation, which you will not get insured against. Again, that's a topic in its own right. There's lots of law in that particular area. Long story short, if you're doing design as a contractor, you want option X15 in. And this particular amendment to it, again, just clarifies what you need to do with respect to certificates. So before I move on then, just to the October 2020 amendments, we've got a couple of questions. So George Brawley, good to see you again, George, first of all. When is an accepted program deemed to be accepted? For example, if the updated program is issued monthly by the contractor, but the PM does not comment or confirm. So the answer to your question, George, depends on whether you're using NEC3 or NEC4. Under NEC3, there is no way to have a program deemed as accepted. If the PM doesn't respond to it, that's it. The contract doesn't give you an express remedy for that. Strictly speaking, it would be a compensation event because it's a failure by the PM to respond in accordance with the contract. But the problem is, what's the loss that you've suffered as a result of that? So it can be a difficult CE to get off the ground. On the other hand, under NEC4, they did change that clause. I think it's in around clause 32 somewhere to do with the revised program. And it basically sets out that the PM has a set time frame to respond. I think it's 2 or possibly 3 weeks. And if they don't respond to that, you can remind them of their failure. And if they further fail to respond, then it's deemed to be the accepted program. So NEC4 does have a mechanism for that, but not NEC3. So hopefully that answers your question, George. Arthur has got a question in the Q&A. What if you still don't have an accepted program at the dividing date? Should you use the most recent submitted program? Unfortunately not, Arthur. Again, clause 63.5, and I'll maybe jump back just to show you the express wording, is very, very express that you use the accepted program to do that. So what would happen in reality is you would need to get an accepted program on the table, and you just need to get it agreed prior to ultimately impacting it. So it is a little bit, to use a better phrase, arse about face, but to keep to the express wording of 63.5, you need to have an accepted program in place. So again, keep the questions coming, folks. Hopefully everybody learns from them as well, and it's a useful way of, injecting a bit of crack into these webinars. On then to the October 2020 amendments, and the first amendment that we're going to talk about is an interesting one, in my opinion, and that is the amendments that have been made to X7, which deals with delay damages. So hopefully everybody knows what delay damages are. If you don't meet the completion date, so again, your obligation is to finish here. If you finish late, then the employer or the client can pin you with delay damages for the period of lateness, for every day that you miss completion under the contract. So that's the big picture, and that's what we're looking at here. Prior to March 2019, it was fairly well settled law in England and Wales anyway, that LAD, so liquidated and delay damages, or delay damages as it's called under the NEC, that they apply up to the termination of a contract. So let's sketch this out. So you have the starting date, which is when obviously you start the works. You have the contractual completion date, which is, as I've said before, your deadline for finishing. If you finish works here, that's grand. Again, there's no LADs because you've done your job. If you finish here, then you're ultimately going to be liable for LADs if you have option X7 in the contract. And what the current wording of X7.1 says is you pay delay damages up until the works are complete, which is fair enough. So if the works are complete here, let's say you're 7 weeks late, you pay LADs up to the, for the value of 7 weeks at the rate in the contract. But what we're looking at here is a slightly different scenario, and that's when the works are not complete. That is when the contractor's performance is so poor that they've missed the completion date and the contract is terminated. Again, the works aren't complete, they are terminated instead. And prior to, as I say, March 2019, the law was very clear. If this scenario happened and the contract was terminated, you would pay LADs for this bit, and you would pay unliquidated damages for the rest of it. So again, liquidated just means a fixed amount. So this could be, £1,000 per day for the first 7 weeks. And then the employer would have to demonstrate their losses thereafter, having to bring in a replacement, having to, the loss of revenue that they would make on the asset, etc. Again, they would have to demonstrate that in the normal way. And that's what the law said prior to March, as I say. Flash forward then to March 2019, and we had this case in the Court of Appeal of England and Wales, which is what that means. And this case examined what would happen in this particular scenario. And it held that on termination, looking at the example that we just looked at with our diagram, there are 3 possible outcomes. And this case ultimately relied upon a lot of different authorities to derive these 3 possible outcomes. And outcome number 1 is the LADs cease to function at all. So again, because the contract has been terminated after the original completion date, LADs go out the window. Second alternative is that you apply the LADs up to termination and it's unliquidated damages thereafter, which again is what the law said prior to March, as we said at the beginning. And then the final, slightly more unusual circumstance, which again, if you were a contractor, this would be, setting off alarm bells, that the LADs continue until the works are completed by others. So again, until the employer or the client brings in another contractor to finish out the works, you are being levied with LADs for every single day up to that point. And again, you can probably see why that's a very unfavorable outcome. But when you think about the logic, that's the 3 possible things that can happen here. And what the court ultimately said is that which of these scenarios will apply, which of these outcomes will apply, is highly dependent on the precise wording of the clause itself. And in this particular case, they held that the LADs did not apply. And we're going to look at the reason why and how that has ultimately impacted on the wording of the NEC shortly. So again, just to confirm, the Court of Appeal said the LADs are struck out and they don't apply in this particular contract. From the employer's perspective, you would probably see why that's a slightly unfavorable result. And this is the wording of both clauses then. So the actual wording from the case in Triple Point and the actual wording from the old NEC or the original NEC. So the wording itself, you'll see, isn't unusual at all if the contractor fails to deliver the work within the time specified, which again, that's completion date under the NEC, and the delay has not been introduced by the employer, which is fine because it would be unlawful to do it otherwise. Then you would pay the penalty at the rate of 0.1% of the undelivered work per day. Again, it's a slightly different way of doing it. It's linking it back to the value of the uncompleted work, as opposed to being a fixed amount. But again, it does the same thing. It is an amount of money that you have to pay if you are late. If there's any contract drafters, any lawyers in the audience, again, do not put that word in there, because penalty clauses, punitive clauses are unlawful in English law. The fact that they've used that word, it wouldn't sort of invalidate the entire clause, but do try to steer away from language like that for obvious reasons. So let's contrast the wording in Triple Point to the wording in the original NEC4, where the contractor pays delay damages, so LADs, at the rate stated in the contract data. That's fine. So it'll be a certain amount of money per day from the completion date, which again is our deadline that we've looked at previously, until completion, or the date on which the employer takes over the works. And therein lies the problem, that this wording is very, very similar to the wording in triple point, where it talks about the LADs applying until PTT accepts the works. So again, completion would have to be by other people or the employer taking over, the employer accepting the work. And as I say, therein lies the problem, because the Court of Appeal, so the England and Wales Court of Appeal, decided in that particular triple point case, using this particular wording, that the LADs were struck out. They were invalid. And that is contrary to the intention of the NEC, where they want LADs to survive termination. And that is why this particular amendment has been added. And we'll look at the amendment now. It's a very, very easy one, just to compare, because all they have done is add in a third bullet point. Third bullet point to say that the LADs will cease to be applied on the date which the project manager issues the termination certificate. So once the contract is terminated, the LADs cease to apply, but up to that point, the LADs are valid, which again, circling back, puts it to the pre-March 2019 position, which is the common sense position, where LADs apply up until the contract comes to an end by whatever mechanism. Finally, in our little meander through the triple point saga, and that takes us to July of this year, July 2021, where this particular Court of Appeal decision was taken to the Supreme Court. And believe it or not, the Supreme Court overturned the Court of Appeal, and they effectively decided that striking out liquidated damages which have been negotiated in a commercial environment, which gives the employer certainty of what they can recover if the contractor is late, taking that out is inconsistent with commercial reality and what the accepted function of LADs is. And it ultimately takes us back to the pre-March 2019 position. And, you know, so strictly speaking, the amendment that we have here to X7.1 isn't really needed, but in my opinion, it makes it absolutely crystal clear. So having it in there is a benefit to everyone involved. So it's a positive amendment in my experience and in my opinion. Good. So next question then is, our next amendment then is all to do with YUK2. It's an interesting one, and it's all to do with linking payment, and to be more specific, the final date for a payment, so the date that the payment must be in your bank account, and linking that to the service of an invoice. So the first point to make here is this or these amendments only apply to the professional services forms of the NEC. So the term service short, and the professional services, and so on. There is no issuing an invoice under the engineering and construction contracts, nor the subcontracts. So you don't need to worry about this if you're under the ECC. So this particular amendment in October 2020 came about after the decision in this case, which was a High Court decision of Rochford and Kilhan Construction. And it all boils down to this. So this is section 110 of the Housing Grants, Construction and Regeneration Act. For those of you that don't know, that is a very important piece of law. It's been around since 1996, which sets out a few things that construction contracts must do. Again, it's mandatory. And one of the things that they must do is set out an adequate payment mechanism. And what that mechanism looks like is set out under section 110. It has to do two things. It has to set out a mechanism for determining the due date for payment, and it has to provide for a final date for that payment. So due date linked to a final date for payment. That's the structure that every contract has to follow. And then we have the operative part down here, the part that this particular case looked at. And it was about the parties being free to agree on the period in between those two milestones. That's exactly what it says. The parties are free to agree how long the period is between the date on which the payment becomes due and when you get paid for it. So it's talking about a period there. Remember that. And that's ultimately where this case went. So just to, again, give a bit more background. So we've talked about that Housing Grants Act. Think of it like a rule book It sets out what your contract must do. It has to have payment provisions that look like this. If it doesn't, it is unlawful. If it doesn't, the law will imply a set of payment terms into your contract for you. So if your contract does not comply, the law will supplement it, and they will use the terms from what we call the scheme for construction contracts. There's a lot more to it than that. This is a complicated enough area of law, but that is the big picture here. And that is what the adjudication that we're about to talk about ultimately turned on. So to give you a very quick overview of the facts, again, in 5 bullet points here, an application for payment was submitted by the subcontractor and the application for payment was not paid. Imagine that. Again, this scenario happens all of the time. The subcontractor who wanted paid the full amount of their invoice, so the full amount of their application for payment, they adjudicated against the main contractor on the basis that the contract terms did not comply with that piece of law that we've just looked at. And because it did not comply, those terms from the scheme were read into the contract. And because of that, they were due the full amount of their payment. We call this a smash and grab type adjudication. And I know there's a few people in the audience that will have experienced this painful process before. So again, that's the big picture. It's a smash and grab. The contractor was incorrect. The adjudicator agreed with the subcontractor that the payment terms didn't work, and therefore they were due the full amount of their original application for payment. The contractor wanting their money back, they had to pay out, because that's what you do if you lose an adjudication, you pay out and you argue later. The contractor took the subcontractor to court and tried to argue that their contract terms were fine and therefore the subby was due nothing. But the court disagreed. And the important part for the purposes of this presentation and looking at the NEC amendments is this final bullet point. So I'm going to highlight up so you can all see it. And this is what we call an obiter comment or an obiter statement. So for those of you that don't know, there's basically 2 things a judge can say whenever they're handing down a judgment. There's something they say that goes towards the judgment itself, the reasons for the decision. We call that the ratio, decidendi. That is Latin for reasons of the decision, decidendi. And the other thing they can say is obiter dictum, something that isn't, going towards the root of the decision itself, something that is said by the way. Obiter, it orbits the actual decision itself. So this comment was said by the way. It's not actually a binding part of the decision, but ultimately it is slightly persuasive. And this is why the NEC drafters decided to change the contract. And the judge said, I think it was Judge Cockrell, I believe, that the final date for a payment has to be pegged to the due date. Again, that's the key phrase there. It must be pegged to the due date. If you don't do that, then your contract does not comply with the Housing Grants Act, and therefore your terms get ripped out and replaced with the standard position under the scheme. If you do not word your mechanism correctly, you run the risk of the court putting a red pen through it and reading in the replacement provisions. That's what this is all about. And that is exactly what this payment mechanism was designed like in this particular case, and ultimately why the decision ended up the way it did. So let's then look at how the old NEC is worded to contrast the new position under YUK2. So just a reminder, this is only for the professional services contracts. This does not apply to the ECC, just as a bit of a caveat. So every month or on a regular period, you will have an assessment date. That's an NEC term that we use. Before that date, the consultant has the ability to submit their application for payment. Again, hopefully that happens more often than not, because if you don't do it, then you run the risk of not getting paid. But that's a separate point. So you have the application before each assessment date. Then, after each assessment date, under YUK2, we have that due date. Again, remembering section 110, every contract has to do this. every contract must have an adequate mechanism for determining the due date. And under the NEC, that wording comes from the original YUK2, which is fine, no issue with that. Remember back to section 110 a few slides ago, the other thing that a contract must do is provide a final date for payment. And this is where the problem starts to creep in, because that final date for payment is not linked to the due date, is it? There is a break in the process here, because if the consultant does not issue the invoice, then the final date for payment is never triggered. It can't be an event-driven thing. It has to be linked to the due date itself by a certain period of time. But for those of you that have read ahead, you might say, well, what about the other part of YUK2, William, that sets out about the final date for payment being 14 days from the due date? Well, if you look at YUK2 under a microscope, you will see that it actually uses these words, that the final date for payment is the later of these two things. So in reality, if you never issue the invoice, the final date for payment using mechanism number 1 above will always be the latest mechanism. Ergo, it does not comply with the Housing Grants Act because it does not link it directly to the due date. And that is what this case is all about, setting out that that mechanism isn't compliant, again, as an obiter statement. What the NEC drafters then did is just fix the problem. They have now linked those two things together, the due date and the final date for payment. And again, just to bring it above board and just for the absolute avoidance of doubt, if this is ever tested, we are now fairly certain that it will comply with the law. So process is the same as before. Consultant submits the application before each assessment date, and then we have the invoice creeping in because you issue the invoice after the assessment date. Now, this period here is still undefined. The invoice just comes after the assessment date, and it's ultimately up to the consultant to issue it as quickly as possible. The quicker you issue it, the quicker you will get paid. And it's the due date itself now that is triggered by the invoice, not the final date for payment. And that is totally fine, because all you have to do to comply with the law is have an adequate mechanism for determining the due date. And this mechanism is perfectly adequate. You will submit the invoice after the assessment date. You can do it in one sentence. That mechanism works. The final date for payment then is linked directly to that, as we'll soon see. Again, slides are slightly out of order here, but the final date for payment, ticking off that contractual box or that legal box under the Housing Grants Act, is linked directly to the invoice itself. So again, it's quite complicated, quite technical in nature, and it's, drawing the distinction here between the old scheme and the new scheme is all about this dotted line, but ultimately this mechanism that we have now complies with the law, or we're more sure that it complies with the law. And then we also have the backup mechanism as well, where if you do not submit the invoice, then there is a fallback in the later of position. But again, both of those mechanisms comply with the Housing Grants Act. One is just a backstop to confirm that the client will not have to pay any sooner than 21 days, but we'll not get into that in any more detail. So hopefully that makes sense. There's a lot of diagrams, as I say. I'm going to provide a copy of these slides. Trust me, if you just work through the diagrams, they're dead straightforward. If you read the diagrams in conjunction with the amendment, it will all start to make sense and it will all click into place. So finally then we have February 2021, and again, we'll use this word amendments slightly loosely. It's not really amendments, it's brand new clauses that have been published to ultimately give us the ability to use the NEC down under and in the Republic of Ireland as well. So again, most Western countries throughout the world suffer the same problems that we've suffered here in the UK with subcontractors not being paid. So most other Western countries have something similar to our Housing Grants Act. In Australia, they have the Building and Construction Industry Security of Payments Act. There's lots of different versions of that for the different states and provinces, but again, they all do roughly the same thing. Contractors are allowed to be paid on an interim basis. If you don't pay them, they can adjudicate. That's the long and short of it. And the same thing happens then in Ireland via the Construction Contracts Act of 2013, which again applies to any contracts post-July 2016. So, realistically, any contracts that you're working under at the moment will probably be subject to the provisions of the CCA. And again, what the NEC drafters have done to allow the NEC to be used in these jurisdictions, they have drafted clauses which make the NEC comply with these pieces of statute law. And that's what the Y clauses do. So, as I say, I was actually heavily involved in drafting this particular clause, and again, claim to fame with my previous employer, so I know it fairly well in an intimate level of detail. And what it boils down to is confirming that the dates when you're talking about payment do not include Saturdays or Sundays or public holidays for the purposes of the legislation. And ultimately, you take those dates out of your computation, which just makes things slightly clearer. But it is one of those little things that can get lost in the weeds and you do have to bear in mind. In terms of the remainder, so these two are the operative clauses, they're the important bits, and they set out and map the terms of the NEC on to the CCA and use the appropriate terminology. And it basically looks like this. So you have the assessment dates every month, that's fine in the standard NEC way, but after the assessment date, the contractor can submit their application for payment. Again, that's slightly different to the standard NEC way, where you submit it beforehand. Personally, I actually like the Irish way of doing it because, it just confirms that this is your valuation date instead of, at this point in time, having to forecast an element of the works. Why would you not just submit it after the valuation date? I actually think the Irish way is slightly, better in my opinion. What the client must then do if they do not like the contractor's application is they must respond to that. And that is the equivalent of, a pay less notice or payment notice in the UK regime. But under the Irish regime, it is called the response. And that comes from the client and not the PM. The remainder of it, again, is fairly straightforward. Why 1.4 just confirms that if the client has suffered a loss due to the contractor, so if the contractor has not installed something correctly and it's caused a problem, then that can be recovered from the contractor effectively as a negative payment notice. Why 1.5 confirms, again, and just like the Housing Grants Act in the UK, if a contractor is not paid in the Republic of Ireland, they can give a notice to the contractor of their intention to suspend performance. And if they actually have to suspend performance due to non-payment, that is a compensation event. And they're able to recover their demob costs and eventually their remob costs if it comes to that. And that clause just confirms that in doing so, in exercising that statutory right, again, it's a right to suspend under the CCA, it will be a compensation event. And then finally, disputes under Section 6. There's one thing that's worth mentioning just about how this is drafted. So under the CCA, it sets out that you can go to adjudication, but you can only go to adjudication to resolve, quote, a payment dispute. What on earth is a payment dispute is the question. Does that mean an argument over liability, yes, no, who's liable for that? Because ultimately that's going to affect the amount that you're paid. Or is that simply to do with non-payment of an invoice or non-payment of a bill? Answer is we don't know, because we've got no particular case law on that turn of phrase in Ireland just yet. But how the NEC has been drafted in this particular case, it sets out that any dispute is a payment dispute. So it's designed to try and, avoid that particular problem. If any dispute arises under this contract, it is deemed to be a payment dispute, and adjudication is therefore available as a remedy, as a resolution process. So it would be interesting to see how that will be settled in the courts, but I think the way the NEC has been drafted here is designed to protect the users by giving them a little bit of certainty. So final, main sort of material slide is a practical point on how to incorporate all this stuff that we've just been describing. And there's two different ways to do it. You could do either or you could potentially do both. I would recommend doing both to, go belt and braces. So in contract data part 1, which is the contract data provided by the client. Again, this is the part you would provide as part of the tender package. You could just add in a line to say, as amended by the January 2019 and 2020 amendments. And again, if there's any more published in future, just add them into that little line there. Or you could go belt and braces, which I've done in the past. I've actually pulled this from a recent contract that I drafted for a client. You could actually add them in as a Z clause. So you'll not be able to see it on the slide here, but this little table is the January 19 amendments, and this very, very small table to do with X7 is the October 2020 amendments. And again, you can just add them in just so everybody knows exactly how the contract has been changed, because the last thing that you want is ambiguity around this on how the contract has been changed. So hopefully everybody enjoyed that. That is the end of the presentation. As I said at the very beginning, I've got all of the materials that you can see on screen there ready to go. So if you drop me an email, there's my email address, I can send those across to you. But I think Engineers Ireland might be uploading them as well. But that's the quickest way to get them if you would like. And thank you all very much. Hope that was good.
Yeah, thanks, William. Just before we finish up, there was one more question in the Q&A from Liam McGuire a little bit earlier.
Yes, I can do that. Liam McGuire, hi William, can CEs be added to accept the programme before they are approved? And if not, how are subsequent CEs evaluated for time if being added to the accepted programme, which doesn't include all CEs? So this is a typical problem. You've got an accepted programme in place. Several compensation events have happened since. What do you do? The short answer is Practice Note 1 deals with this, Liam, in quite a bit of detail, but you combine them all together. You sit down and you determine what the critical path impact is. The likelihood is that only one or two of those CEs is actually going to affect the critical path, and by impacting those, the rest of them become non-critical. But it's just a case of meeting up to get that accepted program in place before you ultimately start to impact it moving forward. So it's using practical common sense to resolve that very, very common issue, Liam. Hopefully that addresses your questions.
Great, thanks, William. I don't see any more questions in the chat or any in the Q&A, but as you said, you've provided your contact details there if there's any further follow-up. As you said, yeah, the slides should be circulated to attendees afterwards by Engineers Ireland, and the recording should also go live on Engineers TV, the Engineers Ireland website, and also the Engineers Ireland YouTube channel. So it should be there to refer back to afterwards as well. So just finally, William, just thank you very much again on behalf of the GB region, and thank you to all the attendees who were patient with the technical difficulties we had at the start. So again, just thank you to everyone. Enjoy the rest of your day and your weekend, and best of luck in the future. Thank you.
Thanks, Daniel.